Yes, Mr. Sims.
Good afternoon, my Lords. My Lords, I think there was just a brief point raised by my Lord Justice Lewison as regards findings made by the judge, and there was the timing issue, if I can put it that way, which has been raised. The clearest point where this is dealt with in the judgment is in paragraphs 56 and 57. If you go to the judgment, which I think is behind tab 7, and if you start at page 87, you'll see this is in the context of Mr. Howard's second submission, which is the first ground on appeal, at paragraph 55, and you can see the judge's conclusions and reasoning in that respect in paragraph 56.
Yes, indeed. I was just wondering what the material was which led him to that conclusion.
And then if you read on to 57,
Yeah.
and in particular over the page to the end of that paragraph, So the short point was that the new scheme, if you like, involved these bare trusts in relation to the property development process, and Mr. Kessler, in effect, accepted in his evidence in the court below that was contemplated right from the outset. There was no change. So I think the judge's findings apply to the objective knowledge of the parties at the time the AR agreement was entered into. There are other passages, I think, which give you the similar flavour. For example, in paragraph 25, you can see in paragraph 25 the judge is talking about the parties considering together whether or not these are CISs, to the same point. So if I can then go back and just briefly complete my submissions on ground 1 and then move on to ground 2, which I've apprehended as perhaps more ground that your lordships want to hear from me further on. On ground 1, what we say is that the approach taken by the judge was informed by the background context, which was that these very schemes were what was in contemplation and what the proposed appointment was for. And that is not challenged on this appeal. And in those circumstances, it's relatively easy then to see why the judge took the approach he did to the interpretation of the key part of the AR agreement and the section under the heading relevant business. That there's an express acknowledgement that the appointment is to cover the very schemes which are operated. And therefore the words, there is no pooling of capital or CIS, in my respect for submission, are plainly and obviously simply an incorrect statement or conclusion by the parties as to the description of the thing they have already identified. I would briefly draw your lordship's attention to this finding by the judge, even though he didn't put it in this way expressly in his judgment, as falling into a category of a maximum wider principle of construction. I would respectfully refer to my Lord Justice Lewison's text in this respect at 9.45 in the authorities bundle. I think the extracts in this respect are behind tab 18, which starts at 327 electronic or 324 of the continuous pagination. And we've included two sections of the text in that respect. One is starts at reasonableness of the result, and then the second section which we've included is falsa demonstratio. and this is to do with descriptive labels attached to certain things in a contract. And in particular, the passage which caught our eye is a summary of the decision of Mr. Justice Nugee in Carr and Thales at paragraph 9.45. This is at page 334 of the electronic, or 331, the continuous pagination. It is well established that once it is concluded that an instrument is intended to refer to a particular person or thing, an inaccurate description of that person or thing will not invalidate the reference. And then he gives the Latin maxim for that, translated as a misdescription does no harm. We've included Carr and Thales in the authorities bundle as well, and that is behind tab 4. It's in the context of a pension case, which looked at a rule which had, in effect, two parts to it. And you can see at page 50 of the electronic bundle, or page 47 of the continuous pagination, the difficulty which arose in that case was a clause which referred to rates of increase by reference to RPI, and then went on to say, as specified by a certain statutory instrument provision, statutory order. Two limbs.
What are you looking at?
I'm looking at Carr and Thales behind tab 4 at page 48, and if you're looking at the PDF locator number, or 45 if you're looking at the continuous pagination.
You haven't got the right numbers, but anyway.
Oh, my apologies.
Which paragraph is it?
The particular paragraph where the rule is contained is in paragraph 2 of the judgment of Mr. Justice Nugee, as it was.
Right.
But so I thought I should just briefly take you to the point that was being considered by the judge. But the part which is quoted from in Lewison is paragraph 75, 76, 77.
Yes, good.
The judge didn't expressly refer to that, but we would respectfully submit that that's exactly what he did in this case. He looked at identifying what the material operative part was of the appointment, and the fact that the parties gave us an incorrect description doesn't matter for present purposes. Now, I don't understand my learned friend to seek to develop, in particular, the submissions he set out in his supplemental skeleton argument by reference to the two cases that he's mentioned there. In neither case was the question arising one of interpretation, which is obviously what Crown 1 is about. I think ultimately where we ended up on that was a conclusion by him, or an assertion by him that, well, the contract may involve some illegality in performance. Well, so what? If that's the proper interpretation of the contract, that's a proper interpretation of the contract. I'm not sure how to assist my learned friend on this appeal, because ultimately the question is, as the judge found, what is the proper interpretation of the agreement, not the question of arguments about enforceability retrospectively. And I think he accepts that this doesn't take him anywhere independently of his other submissions. But I respectfully agree with the observations made by Lord Justice Lewison that the cases he refers to do have to be viewed in the context of Patel and Mirza. And indeed, if you look in Anderson and Daniel, one of the cases he refers to, that distinguishes between who, as a matter of public policy, may be prevented from being able to seek enforceability of agreement. Of course, that's all a long way removed from the fact pattern in this case, which is the retrospective consideration of the agreement, which I think my own friend concedes is in writing in any event. So the question of enforceability or otherwise doesn't actually arise in this case.
But in this case, JHM weren't, I think, under the terms of the agreement, required to market these schemes. They had permission to, on your interpretation. So this is not a contract which had to be performed illegally.
No. Your lordship's right. I don't think. My own friend is not. I think advancing a point. I don't currently understand those cases to advance his point any further. I simply thought I should just cover them off because I think that's where we ended up. And what I would say is, in any event, I think there is a passage in my own friend Lewison where he suggests that a consequence might be to render the contract of no legal effect or void. I would respectfully disagree with that legal analysis. I don't think it follows. Even if we're one to contemplate a contract which may be viewed as unlawful in its performance, that wouldn't necessarily mean that it's void ab initio. It would simply be a question of procedural enforceability, obviously in the context as between the two parties. And you see in Patel and Mer's analysis of cases where there was a third-party involvement, such as Hardy, where involved the MIB, where different considerations arise. So, but I think it's all a long way from the critical crux of the submissions in this case in any event. So on ground one, we simply say that nothing has been identified by my learned friend in terms of the background context to take us away from the conclusion that it was these very schemes which were to be what the agreement was for. And in those circumstances, the misdescription doesn't cause any harm so far as the proper interpretation of the agreement. It's simple as that, really. Ground two, as I've said, deals with the different question of Section 39 responsibility. In some of the cases you see it referred to as Section 39 liability, but actually for the purposes of this appeal it's about Section 39 responsibility, because establishing the rule in Section 39 alone doesn't get you home. You obviously have to establish some other rule breach or some other conduct by the appointed representative, which then enables you to establish a claim. So the focus of the appeal is not on liability and fault issues as such, but on the gateway provided by Section 39.3, which provides for a statutory vicarious liability, which has as its starting point a consideration of the AR agreement in order to ascertain what the prescribed business activity is, but which is subject to Section 39 requirements. In other words, once the AR agreement has opened the door to a conclusion that a certain type of prescribed activity has been permitted, subject to questions of what part of that business can be cut down, that is the issue rising today. And I think I indicated I was going to take your lordships to some of the cases to see what they say about the approach they've taken to Section 39. I'll come back to the wording in Section 39 in due course, and also look at the judge's approach to Section 39 in the judgment, and why we say the judge was right to reach the conclusion he did. But starting with the case law, if I may, in relation to Section 39. The first case, which I think is typically referred to in this context as consideration of Section 39 is the first instance decision of Martin. And if we go to the authorities handbook, and look at tab 7, please, at page 114 of the PDF or 111 of the continuous pagination. And you can see this is a decision of Mr. Justice Jonathan Parker, as he then was. And if you look at the head note, you'll see that it was considering the predecessor legislation to the 1986 Act rather than the current Act before us. But the critical part of the judgment, which has been referred to in subsequent cases, is in paragraph 5, and if you look in the internal report pagination at page 427, you can see the way that it's put in this case is that the agreement in question has a number of express limitations, so looking at 5.2.10. But it's accepted that such limitations take effect subject to the statutory agency imposed by section 44 sub 6. That's obviously the predecessor section. And then you can see that the application of that is then developed in 5.211 and 5.212. And in particular, you see the reasoning in 5.212 as to the width of the concept of investment advice, and that being on the facts of this case, advice as regards the advantages of a particular product and include advising or recommending it's appropriate for the client to purchase a particular product. So it's a case where there's a potential mixture of regulated activity and non-regulated activity. You have a business activity which is construed as by reference to the business activities in the previous definitions of the prescribed activities, and then you see the application of that to the particular activities in question as taking a broad approach having regards to what that particular activity will cover. The next decision in time, I think, is the Ovcharenko case, which I think Malone Friend referred to but didn't take you to. Ovcharenko is behind tab 8. And page 140 or 137, continuous pagination. And this is a decision of His Honour Judge Waxman QC, as he then was. And you can see the issues arose in the context of an application to set aside an argument to do with Section 9 of the Arbitration Act. But in paragraph 3, you can see that it's concerned with a second defendant who is the authorised person and an authorised representative being D1, and in particular provisions of the Financial Services and Markets Act. The clauses are set out in paragraphs 7 and 8, and then we see the reasoning and the parts that we've marked up, Your Lordships, at paragraphs 32 onwards. And we've sidelined the passages 32 onwards. I would place particular emphasis, to Your Lordships, on paragraph 33 and the second sentence. my lords, what you see in this case is a distinction between internal contractual restrictions or limitations which operate inter se, as described by the judge at paragraph 35.
In paragraph 33, line 5,
yes,
I assume that without law should read without more. Is that right?
That's how I've always understood it, Lord. Yes, this is an extempore judgment.
One,
It may be
two,
there are
three,
errors in transcription.
Does no more and no less than enable the claimant without law.
without more, yes.
Should read without more.
Without more, you're quite right, yes. Yes, I skipped over that, and the brain may have reinterpreted it without. You're quite right, without more. And then we have the observations in paragraph 49, making the distinction between section 39, as he describes its statutory liability, and the law of agency. And again, the same point is made in paragraph 54. The next decision I was going to take you to is Tenant Connect, which is behind tab 11. Decision of Mr. Justice Ousley in the Administrative Court, and it's 226 or 223 in my bill, certainly. Tab 11, Tenant Connect. And you'll see that here, again, the question is section 39 responsibility. And you see the argument being made was that the advice in relation to the disposal of certain investments was regulated activity, but advising them what to do with the money was said not to be. And you can see that the submission to that effect is then also summarised within the judgment at paragraph 51, and then are rejected. And it's in particular the paragraph, passage from 52 onwards, where there's a consideration of the principles and previous case law. And ultimately we end up at the conclusion in paragraph 59. And the public protection role played by section 39 is emphasised in particular in paragraph 59 towards the end of that paragraph, at around F to G, starting with the sentence that the legislative provisions should be construed so that. I don't know if you see those words. This is internal pagination of the report 749, if that's easier to locate. There's some further discussion and consideration, I should say, of section 39 and also from paragraph 61 onwards, which contains a discussion of Martin and Britannia in Ovcharenko, etc. And at 64, you can see that the conclusion that the activities are so closely linked that they amount into regulated activities, and tells the conclusion that they come within section 39.3. then have a review of that authority at first instance in Anderson and Sense by Mr. Justice Jacobs, and that takes us to tab 1. And I'm not going to take you through all that review, but suffice to say that it starts within the part that we provided you within behind tab 1, under the heading Analysis and Conclusions, at internal pagination 1632, or if you want the PDF, it's page 9, or the continuous pagination on the bottom middle, it's page 6. But the punch point, if you like, the conclusion is in paragraph 139.
So you say that supports the proposition that the question of whether the client has been given is of a particular character or has been given a particular form of advice in advance of getting the transaction, or being offered an inducement, for example, may have other effects, but it doesn't affect the engagement of section 39.3.
Exactly. It has effect inter se as a matter of contract, but not on section 39.
Because effectively it's a consumer protection section.
Exactly. I have to be a little bit careful with that submission, because it's not just a consumer protection provision. Section 39 does provide consumer protection, but it also it does two things, doesn't it? It provides exemption from liability as well as a conferral of a long stop liability. But certainly one of its purposes is to provide consumer protection under section 39.3. And so we would respectfully submit, when you approach that purpose and that question, it is right and proper that you approach the question of what part of that business can be cut down for the purposes of section 39.3 by reference to the prescribed business activities as your, if you like, the field from which you cut down. Now, obviously, this was considered by the Court of Appeal to some degree in Anderson and Sense. I shall probably turn to that case now, just to see where that takes us in terms of the reasoning. And to cut a long story short, the key part of Anderson's Sense for present purposes is in relation to the debate about the what and the how in paragraph 40. But there's some relevant discussion before then we should probably briefly pick up on. And in particular, see that the part of the reasoning in this respect starts really in paragraph 29 of the judgment of Justice David Richards, who starts with the language of section 39. And having started with that language, he then considers what are the three critical steps. In other words, first you have to have the contract, which permits the business of the prescribed description. And that obviously then links us into Regulation 2 and the categories which we've already looked at. The second then is, must be someone whose activities in carrying on the whole or part of that business has been extensively noted. And the difficulty for my submissions on the appeal was that the legislature plainly contemplated on a natural meaning of the language, that you could cut down part of that prescribed description. And that ultimately was the focus of the reasoning of Lord Justice David Richards. But that could operate effectively in this case, because the part of the business was being cut down was a specific channel of a product within the specific field which formed part of the generic business description. And so all the cases like Ovcharenko and Martin and Tennant didn't really meet that point.
It's not so much the product that was excluded, but the way in which the product was to be sold, wasn't it?
Well, it was it was confining the advising investments to specific companies. So
yeah, you could sell any product as long as you did it through a company agency.
Well, I think I think the company agencies were intimately linked, because in that case the company agencies would have been, for example, a bank or so it was intimately connected with the business activity. It formed part of the wider business activity. It's very different, in my respectful submission, from the question of who that business activity may receive it. Do that way. Who the person at the end of the process.
That's not actually what Lord Justice David Richards says in 32. All he says is effectively it's a question of interpretation of the contract. In order to determine the extent of the acceptance responsibility, necessary to refer to the terms of the document by which the authorised person accepts responsibility. In our case, the contract.
Well, my Lord, I don't think you can take that as an absolute, because you could write into the contract, for example, I'm only going to be accepting responsibility for competent discharge of business, and that proposition was accepted by Lord Justice David Richards in paragraph 40.
Yes, but what he says at the end of the paragraph of 32 is the acceptance of responsibility may relate to part only of such business as stated in the written acceptance of responsibility. That's the key point.
But that doesn't. I don't think one can say you can only look to the contract, and if you see a restriction in the contract, ergo you must fall outside section 39(3). That wasn't what Lord Justice David Richards was saying. What he was saying was this particular type of restriction fell into the what? In other words, the particular channel or part of the business activity was constricted to company channels, company agencies, certain specific types of investment.
Is this really very helpful when we've got a perfectly good statute which tells us what test to apply? I always find when courts try and impose their own gloss, it may work very well for the case they're deciding, but it doesn't work very well for every case. And this, I mean, personally, I'm speaking only for myself, I find this what and how totally opaque. I just don't think it's a distinction that, it may be the distinction in that case, but I would prefer for my part to look at section 39.
Well, I'll come on section 39, but I think that the important point to not lose sight of is that what is clear is you cannot cut down, as accepted by Lord Justice David Richards in this case, on clever drafting or even not clever drafting, by reference, for example, failure to properly conduct business, even though you might come up with a form of words which suggest that you are only accepting responsibility for competently discharged business, if I put it that way.
No, I get that. And the way he applies his test is at paragraph 58 and 57.
57. Yeah.
And there you see, it fell outside because it was advising clients to entrust their money to a scheme which didn't involve the use of a company agency.
Yes.
It fell outside the business for which they'd accepted responsibility
Yes.
under the contract, effectively.
But that is can be properly rationalised if one goes back to the section, which I think is probably where you prefer to start. But
that's really my point.
I don't have a problem with that, but I think it's important to understand that Anderson Sense does properly recognise it. It's not simply a question of reading the contract. You have to start with the contract to give you the foundation to get you into section 39.3. Absolutely no doubt about that. And in our respectful submission, that is necessary in order to meet the requirements of section 39.3. But having opened that door to the prescribed business activity or part thereof, you can't then cut that back and say, well, I'm only, for example, accepting responsibility for competently discharged, or where you don't grant an inducement, or etc. etc. So
I suppose in section 39 terms, you would say that the distinction between conducting business competently and conducting business incompetently does not represent two different parts of a business activity.
Exactly. And misclassification of a customer is a classic instance of an incompetent state.
But more precisely, it doesn't represent a part of the business of a prescribed description.
Exactly.
Which gives you the entry into section 39.1.
Exactly. So
and your point, I think, is that business of a prescribed description might include business that is to sell only bonds issued by Scottish widows.
Exactly.
But does not include selling bonds issued by Scottish widows to X as opposed to Y.
Marlo's got my point.
Yeah.
The definition does not contain the client classification. Yeah. That I think, stripped down to its ultimate simplicity.
And the judge went further and said this would actually hollow out the utility of section 39.3.
He did. I think there are two strands to his reasoning which we would respectfully seek to uphold before this court. The first is the business definition point, and the second is the erosion of the protection of the public point. And we would draw some parallels and analogy with some of the other cases in different contexts, admittedly, in relation to braided advice, etc., supporting that second proposition.
But if you look at it through Mr. Howard's end of the telescope,
yes,
which obviously you wouldn't want to trouble to do.
Yes.
I suppose you could say that business, or part of the business of a prescribed description, is business available to be sold to professional customers.
You could, and as a matter of contractual...
Why is that wrong?
There's nothing wrong with it as a matter of contract. We're not saying that can't be included in the AR contract. But what we're saying is that because the definition of client doesn't form part of the prescribed description within section 39.1a, you are not actually, once you accept responsibility for the whole or part of that business activity, a restriction on client is not a relevant. It's not within the cutting down.
But why then in Anderson is the particular type of bond?
Because it does actually form part of the substance of the business activity within the prescribed description. Because you may recall you have advising investments and you have various different categories of...
Yes, but there's no difference between a Scottish Widows bond and a Norwich Life bond. There's no substantive business difference.
No, but there is the ability functionally to see in those circumstances how that that forms part of the business, which forms part of the prescribed description. Whereas with a client, it doesn't. It's all that.
So where's but the prescribed description comes? I can't remember where it comes out of those words.
It's in section 39(1)(a)(1).
No, I know that.
Oh, sorry.
I'm looking at it. Where does it? Where is it referred to elsewhere in the? So what does it mean?
Oh, you then have to go into regulation 2, and I think in Anderson's sense it was accepted that this was the way that the scheme worked.
So where's regulation 2?
It's behind tab 15 at page
307.
3, yeah, so in mine it's 309 or 306, but it may be a different page for you, I'm afraid. So that's where you get the
Sorry, I need to see regulation 2. Where is it? I've got article 25.
So behind tab 15.
I don't have tabs.
Apologies. Page 309. Does that work in a PDF locator bar?
Regulation 2 seems to be on page
306.
306.
Oh, 306. 306.
So descriptions of business for which appointed representatives are exempt. Is that it?
Yes.
And then
So-
it's article 2(1).
And then it's really A and C, which is the focus in this case, and we're also the focus in Anderson's sense. If you turn back to Anderson's sense in the Court of Appeal, this precise point was addressed.
I'm sorry to be so pernickety about this.
Yes.
This is a description of business for which, but the words that we were previously looking at in section 39(1), which is business of a prescribed
description. Yes.
description.
So the prescribed description is the business is prescribed in generic terms in regulation 2.
So, and the types that are concerned here are an activity of the kind arranging deals on investments,
And advice.
where the arrangements are or with a view to transactions relating to securities, and an activity of the kind specified in 53, advising on
Yes.
investments.
I think you
So
see.
you say that do you say that the description of the business, a business of a prescribed description,
Yes,
it is a generic activity?
exactly.
You say that?
Yes. So
So
you see.
It's
If
a
you go back
generic
to-
activity which is arranging deals,
Yep.
but not for any particular person, or advising on an investment, but not to any particular
Exactly.
person.
And you see that summary in paragraph 15 in Anderson's sense in the Court of Appeal.
Sorry, Anderson, paragraph 15.
15, and then also this particular point about the prescribed description and that being the business is prescribed in generic terms in paragraph 31. So it's 15 and 31.
Does it follow on your interpretation that if an AR is appointed under a contract which restricts his activities to advising professional clients or eligible counterparties, but he in fact advises retail customers, he is exempt from the general prohibition? Irrespective of the authorised person's own liability, is the AR himself exempt?
He gains his exemption in relation to those prescribed activities, so the short answer is yes.
That would be an odd conclusion, wouldn't it?
Well, no, because it goes back to the question of proximity with risk vis-a-vis criminal prosecution. So the way that the Act is intended to operate is intended to operate, in effect, a licensing regime in relation to certain generic business description activities. And an AR who, for example, mistakenly advises a retail client rather than a professional client would not want to slip out of the regulatory perimeter because of that and end up being subject to potentially criminal sanction because they're in breach of Section 19.
So if I'm an authorised person and I want to appoint an AR, but I don't really think he's terribly well experienced and I'd rather he dealt only with professional clients, you say, well, you can do that as a matter of contract between you and the AR. What you can't do is protect yourself against vicarious liability, for want of a better phrase, if the AR goes off the rails and starts selling to the man in the street.
No,
You just can't do it.
No, you absolutely can protect yourself, and you should protect yourself, and you should be active in your role. Your role as in effect, lending your license to the AR is not here's the money, go off and do what you want.
No, you have to supervise.
You have to supervise. There's a responsibility as well as a benefit to the authorised person to engage in activities of ensuring that the AR keeps within the regulatory perimeter and keeps within the contract. That's specifically provided in the supervisory rules.
But your point is that if you look at this regulation, it talks about the business being prescribed as
Yes.
being arranging deals in investments.
Yes.
So you can understand Anderson because it can be arranging deals in one type of investment rather than another type
Exactly.
of investment. But you can't find in any description of the business a restriction on the type of person for whom the business is arranged.
Exactly.
So if it is advisory, it doesn't say advising X or Y, it just says advising about investments.
Exactly.
And if it is arranging deals, it doesn't say arranging deals in investments for customers who are
Professionally,
or
whatever
have
the
particular
classification.
characteristics.
Yes.
It just says arranging investments. And so that's where you really say the line is to be drawn. And in answer to my lord, you say, well, that may be slightly odd in the sense that Section 39 gives liability even when it looks as if you're stepping outside the authorised areas, but that is the protection. The section is broader and is to be construed as giving broader protection.
Exactly.
Yeah, okay.
And my lords, I think.
But that does mean, doesn't it, that the exemption which the authorised person confers and for which they have to accept responsibility is wider than their own authorisation, because the authorisation which KVL have in this case is limited to professional clients and eligible counterparties. So by giving authorisation in those terms to the appointed representative, they are in fact exceeding the scope of their own authorisation.
Sorry, my learned junior is eager to put something out to me. I have listened.
Yeah, okay.
I think this may have some bearing on the point my Lord Justice Nails has just raised, but if I don't know if we have section 31
So section 31 of what?
I'm just looking at section 31 of business, whether it's in the bundle.
This
I don't think it is. Section 31 is the provision which deals with authorised persons, and it identifies that in particular, a person who has a Part 4A permission to carry on one or more of the regulated activities is an authorised person. One then goes back to section 19. The general prohibition applies as regards an authorised person under section 19, the way it operates is no person may carry on a regulated activity or be report to do so unless he is A, an authorised person, or B, an exempt person. I think what Maloney Junior is seeking to draw out from that is that once you're an authorised person, the fact that you may step outside your permission doesn't...
Well, that's section 20. Because section 20, I'm sorry, obviously we haven't got this, but I happen to have brought my book, which is far too small for me actually to read, but I'm going to try. It says, if an authorised person carries on a regulated activity otherwise than in accordance with permission given to that person under Part 4A, blah, blah, he is to be taken to have contravened a requirement imposed on him by the FCA under this Act.
Yes.
It doesn't say he's no longer authorised.
No, it means in effect that is a breach by the authorised person under the Act, which might give rise to a damages claim. But it doesn't involve them in a contravention.
Your junior is very keen to talk to you. He can talk to us if he likes. We're delighted to hear from you.
Yes. I think Maloney Junior is drawing attention to the point I think I was just about to make, which is that contravention doesn't, except as provided by section 23(1)(a), make a person guilty of an offence. So
doesn't make
a person guilty of an offence.
Right.
So the concern is in relation to section 19 vis-a-vis an exempt person as opposed to an authorised person. Obviously, an authorised representative is an exempt person. The concern is that gives rise to obviously a breach of the general prohibition and criminal sanction. The same concern does not operate in the same way vis-a-vis an authorised person once you get your authorisation. But I think the short point we would make is that ultimately the question of what the section 39(3) gateway permission is defined by reference to the definition of business we see in the statute. Doesn't cause a problem as between the AR and the authorised person if the authorised person is acting diligently. If they're acting diligently, they will be supervising the authorised person in order to do two things. One, to ensure they stay within the regulatory perimeter, and two, that they will stay within the contract. And the reason why this case is very different from Anderson's sense, in Anderson's sense, the Ponzi scheme was hidden from the authorised person. And it was very difficult indeed in that case to see the justice of finding the network liable. It was someone who'd gone rogue. The fact pattern in this case is very different. There is no indication that an authorised person who's performing their duties properly should not know about client classification. Does not check it. In fact,
well, the judge was not persuaded that you had a summary judgment on supervision. So don't we have to assume that they may at least possibly have been performing their supervisory role properly? Nevertheless, this goes on.
Well, we've got documents in the supplementary bundle which are taken from disclosure provided by Mr. Kessler, which shows the process of them going through the client provisions. And yes, I accept that we.
Well, I know
have,
you might say what the judge ought to have found in our favour that
No,
they didn't supervise
I'm
properly,
not-
but you're not saying.
No, I'm not saying that, because in fact the question of client classification is a quality in certain, and this is the point I was going to come on to, the practical point. I think I've dealt probably as far as I can with the conceptual submissions. I'm moving on to my practical submissions. My practical submissions are that actually, as a matter of practice, the exercise of client classification is not a straightforward tick box exercise my friend would suggest. It's a qualitative assessment, and you can see that from COBS 3. We've included in the authorities bundle the key provision, which we seek to rely on, which is 3.53. But we thought it would assist your lordships to have COBS 3 generally, because it contains the definition of client at 3.2.1, etc. I don't know if your lordships have to hand the full, the full Monty, so to speak, of COBS 3 or not. But you can see definition of client in 3.2.1, and then we can see then the definition of retail clients at 3.4.1. Being a client who's not a professional client or an eligible counterparty. I think we referred to a few of these provisions without actually having them in front of them this morning. And then we have professional clients at 3.5. And you can see a professional client can be a client that's either a per se professional client or an elected professional client. Per se professional clients we can skip over, but you can see they refer to various different institutions. And then so far as elected professional clients, you can see there's the ability to, by a firm, to treat a client as an elected professional client if it complies with certain criteria. 1 and 3 are where applicable 2 engages here. So let's look at 1 and 3. 1, the firm undertakes an adequate assessment of the expertise, experience and knowledge of the client that gives reasonable assurance in light of the nature of the transactions or services envisaged, that the client is capable of making his own investment decisions and understanding the risks involved. The qualitative test.
The detail doesn't matter, does it?
Sorry?
The detail doesn't matter. What matters is that there are detailed provisions about how firms operate to identify and warn and explain and approve clients in these rules, which the legislation must be taken to have had some knowledge of.
Yes, but I think what I was trying to develop was my practical submission, which is if you compare what an AR needs to do in order to, for example, decide whether it can properly treat someone as a professional client under 3.5.31, and you compare that, for example, if we go back to the authorities bundle and look at COBS 9, which is assessing suitability.
Why can't we look at COBS 9 in this?
I'm not sure if we provide you with COBS 9 as well in toto, so apologies for having to dart around. But it's behind tab 17 at page 321 of the continuous pagination if you're using the bottom centre continuous pagination. And you can see in terms of some of the things needed to be done in order to assess suitability, obviously there's certain steps which have to be taken, but for example under 2, when making the personal recommendation on managing his investments, the firm must obtain the necessary information regarding clients who have knowledge and experience in the investment field, etc. And then 9.2.2, information that's needed to be obtained in order to see whether or not they have the necessary experience and knowledge. That inquiry, that assessment, entirely overlaps with whether or not this person may be viewed properly as an elected professional client. So we have the concession by my learned friend that suitability is a how question rather than a what, to use the phrase from Alice in Sense. Yet I'm almost
Well, you say it's all part of the same process and it's intimately connected, and it would make no sense if it was if this
Your
was a what and that was a how.
Your Lordship has the point.
Yeah.
There is also this oddity to building on the practical issues that if you go back to COBS 3, you can have a person who may start being a retail client, become an elected professional client, and then may be treated later on as not suitable as being an elected professional client. And for that final point, you can see, for example, under COBS 3.7.1, the firm must allow a professional client or eligible counterparty to request recategorisation.
So which one are we at now? 3
But
points.
back in COBS 3,
Oh, right.
the version I think was lodged this morning. So I
Future
would
reference, this is not the best presentation of authorities to the court that I've ever seen, Mr. Sims.
No, I think both Malone and I would accept criticism on that part and apologies to the court for not providing you with a better service. I will not try and give my justification. I'm tempted to do so, but I think I don't think it would assist your lordships for me to. I will take shared responsibility with my own friend and take it on my shoulder. But our short point is this: that but if you look at 3.7.1 and also actually 3.5.9. 3.7.1 is the ability for someone to request to be recategorised, but 3.5.9 is where the firm becomes aware that actually the conditions which have meant that the categorisation is appropriate is no longer appropriate, then the firm must take action. I think that partly responds to one of the points my Lord Justice Lewison was making earlier, that you can see here in relation to client characterisation. That there is supposed to be active consideration of the issue, and it forms an inherent part of considering the quality of how the business is conducted.
Presumably, the recategorisation would only apply to new business. Is that right? I mean, if you've elected validly,
yes, I would accept that.
And you've made an investment,
yes,
then.
But I think
stuck with that level of
I think it might have some relevance in the context of promoting a scheme and advising in advance. There is the practical issue that there is fluidity, if I can put it that way. Well, the only point I haven't dealt with head on, so to speak, is Malone and Friend, I think, suggested in some shape or form the status of the client in some way is a what question rather than a how, and I think he builds on that argument to say, well, you can have perfectly correct advice, ergo it's logical to treat the status of the client as a what question rather than a how. But that analysis presupposes that the entirety of the how question is based on the quality of the advice given. And you can see from cases like Ovcharenko that that's not so. In Ovcharenko, for example, the issue in question was to do with inducements. And the final point we would make is this, that the oddity of Malone and Friend submissions is the one area where you would hope that legislation would provide best protection is to the retail client. Yet, if Malone and Friend succeeds on his ground too, the only person who will remain with a judgment out of the 26 investors is the person who is the properly classified professional client.
So you were going to use an extreme word to describe that result. like absurd or stupid.
It's putting it at its lowest counterintuitive that would be a sensible end result to the legal analysis your lordships may be considering, or more precisely, my learned friend is urging on you to adopt. My lords, I think probably those were the main points I wanted to get across to your lordships. I'll check if there's anything.
Anything else? Well, thank you very much, Mr. Sims.
My learned junior was keen for me to emphasise one further point. I think your lordship's got this point already, but I think the point that sought to be emphasised is that so far as an AR is concerned, and of course my clients are not ARs for present purposes, but obviously we are advancing those arguments in order to succeed in establishing a claim against the authorised person, is that the AR would lose exemption under section 19 simply because of a simple mistake on categorisation, classification. So the consequences of potentially, because they, on the learned friend's case, section you're treating.
No, you said, I think in answer to a question from me, that the extent of the exemption is by reference to the class of prescribed business.
Yes.
In the order.
So
the question of responsibility is, at least in part, governed by the contract. And I think I asked you what happens. Does the AR lose his exemption if he steps outside the contract? And you said no. Now, you may...
No, I think...
You may make a difference.
We made in cross purposes. Was the question by reference to an authorised person or a...
No, it was about the AR. I asked you both, actually, but AR.
Well, in which case, if I gave the wrong answer, then I apologies.
What is the answer?
The answer is that if the appointed representative does not have the benefit of Section 39 exemption, and Section 39 exemption goes hand in hand with the license, if you like, then that is a breach of the general prohibition under Section 19 for the AR and exposes them to criminal sanction. It's not for the authorised person. It's a different consequence of the authorised person. The way that the scheme operates doesn't expose the authorised person in the same way, which may be a compelling factor in favour, and just goes to show the leader should always check with their junior before finishing their submissions.
Yes, good. Well, thank you, Mr. Sims. Mr. Howard.
My Lords, I just want to say a couple of brief things. First of all, Mr. Sims is last man standing in possession of a judgment point. I don't accept that's curious or absurd at all, because the person who will retain his judgment is the professional investor, and it was precisely a professional investor in respect of whose affairs my clients agreed to accept responsibility. So there's nothing odd at all.
These are the forensic points, but maybe we have to...
Well, I admired the learned friend's forensic flourish, to some extent prompted by your lordship, so I thought I ought to try to make fire with fire.
Maybe.
But the more serious point is this in my submission.
Yes.
We know, because Anderson and Sens tells us, that if, to use my Lord's analogy, there is a company agency with Scottish widows but not with the Norwich Union, and business is done with the Norwich Union, and that is out with the permission. And as my Lord said, there may be essentially no difference between the two products, but there's responsibility for one and responsibility for the other. And in my submission, it's much more important to have controls on the nature of the client, because as we've seen, retail client is the default position, and I don't suppose I need elaborate on the submission that retail clients are likely to be more vulnerable than professional clients or eligible counterparts. And one also has to bear this in mind. Not every appointed representative breaches his agreement, and it may well be, from the point of view of consumer protection, that it is a good thing for an authorised person to be able to say to his AR, as Lord Justice Lewison was saying earlier on, look, I don't think you've got the abilities to deal with retail clients. I don't want you to touch them. And many ARs will take that very seriously because the consequence of breach of their permission is, as we've seen, liabilities under Section 19 and so on and so forth. And the other general point to be made, this takes us back to Anderson, and I won't read any of this out because your lordships have the references. But Lord Justice David Richards was looking squarely at the practical consequences, the need for the authorised person to be able to take account of the breadth of and experience of his potential AR and to his own breadth and experience. And it is with great respect no answer to say, oh, well, we can always fall back, so to speak, on the supervisory element of this regime. Because as Anderson shows, and as my lords will probably deduce in any event, the supervisory system needs to be designed around what the authorised person is expecting the appointed representative to do.
But I think the consequence of your argument, I think, is this, isn't it? That if you as the authorised person, appoint an
appointed
representative,
yes,
and you say, I don't want you to touch retail clients, you can
yes,
only deal with professional clients and eligible counterparties.
yes,
And in good faith, the AR misclassifies somebody as being within the permitted clients, but who is in fact a retail customer. You are not responsible for that misclassification.
that would be correct, my lord. And unless, of course, and this is a possibility, my learned friend showed you the rules in common.
Yeah.
Suppose that the authorised person, in the course of his supervision, looks at these opting up certificates, I will call them, if the Lord has seen what the document has to contain, and sees that they are not being properly completed, or they're not being signed, or when he audits a file, he looks at the written record of what they asked the client about experience and so forth, and what they were told, a competent supervisory system will, in those circumstances, cause the authorised person to go to his appointed representative and say, look, this simply isn't good enough. It's not a complete answer to my lord's point, I accept, but one would not have, as it were, misclassified individuals wandering around with nobody keeping an eye on them.
And what remedy, if any, would a misclassified client have against the authorised person for failing to supervise?
You can sue under the sub rules.
Under the
supervision rules, SUP.
Right.
Like everything, it's contracted into a little acronym. And an attempt was made to do that at first instance, Anderson sense, and failed with the facts. But the availability of the cause of action is not in doubt.
It's a bit strange, isn't it, that Lord Richards, as he now is, thought this was a really rare situation and always going to be really easy to be distinguished between the what and the how. If this large group is excluded from the how and becomes what?
I'm sorry, my
large
lord.
Group of clients and how clients are categorised, and which overlaps so much with the other section. I can't remember what it's.
The bit in Hobbes 9, I think it is, about suitability.
Exactly, supervision. Yes. I mean, it would be strange that one would see that as the what of the business, the prescribed business, when it's so detailed and complex to distinguish one from the other. I mean, I'm just asking for your...
I wouldn't accept that it's necessarily that difficult or that complex. It requires an assessment to be made
an
by...
individual can be one or the other.
Yes.
lots of individuals present with a trading name, they may still be a natural person. You know, there's all sorts of complexities, and you've got to go through lots of hoops. Is that really the business, the prescribed business?
It's a permissible restriction on the business to restrict it by client category.
Okay. And permissible description on the business.
Yes.
Yep. Okay.
I mean, Lord, there are two other points. One is that a client is a retail client unless otherwise categorised. So there is a default position. And if you're not certain, and or the client doesn't sign the necessary certificate, then he stays as a retail client. So we suggest that it's not actually as tricky as all that. And that the balance that Lord Justice Richards was striving for in my submission in Anderson's sense is a balance between giving Section 39 a proper ambit for the protection of the consumer, but also, and this is very important, enabling the authorised person to structure the way it does its business and the way it does its supervision in order to stop errors and losses. And that, I would respectfully suggest, is just as important an aspect of consumer protection as being able to sue under Section 39 if things go wrong. So, my lords, unless I can help with anything else, that was all I wished to say in reply.
No. Well, thank you very much.
Sorry, my lord. My learned junior is trying to send it to writing.
I think we should have adhered to the normal practice now of allowing both your juniors to address us on a discrete point, but we didn't make that point this morning, so we won't make it now. Future reference.
We did think on our side of the court whether there was a particularly discrete point that
Very good.
we were not able to identify.
And what is the point your learned junior would like to make to us now?
I think she believes
In
that
the
I've already
dying
made
moments
it.
of the case.
Ineptly, I haven't made it, but I have made it. So.
Okay, thank you. Well, thanks to you all, both leading and junior counsel, and also your instructing solicitors. We will take time to consider our judgments, and we will hand them down in the usual way. And when we do, please use the draft that you get only for the purpose of agreeing an order and costs and any other directions that may be necessary for the future conduct of the case. And if you can't agree, we will deal with all those matters in writing. But hopefully you will be able to. Thank you very much.